Good evening. Happy Monday. Chili Decastro has treated us with another motion to correct the record, nunc pro tunc. This is document 80. He has titled it Plaintiff's Second Motion to Correct the Record. There's technically no motion for reconsideration in federal courts. I've seen courts refer to rule, I'm going to say 54B, as a rule that can be used to deal with interlocutory, i.e. non-lawsuit ending orders. Things short of like a motion to dismiss, motion for summary judgment, something like that. It's something short of that, like discovery motions, things that don't end the lawsuit, interlocutory. I've seen Rule 59E and Rule 60B, yeah, to deal with final orders, like motions to dismiss, motions for summary judgment. But there's technically nothing like a motion. There's technically no motion called a motion for reconsideration in federal court. Now, the First Circuit allows motions for reconsideration. The court will kind of fill in the blanks because the court uses the language in the motion, not the title that the moving party has placed on it as controlling. It's not what you call it, it's what you're asking for that's important to the court. And you also have to remember that in a lawsuit, the judge, the trial judge, is like the referee. And you shouldn't argue with the referee, because on coin flips, where it can go either way, if you irritate or upset the referee, the referee is more likely to tip that 50-50 against you. So it's never good to argue with the referee. It's never good. And you also have to remember, it's kind of like arguing with the cop on the side of the road. I mean, technically, the cop could be wrong. But you don't argue with the cop. You don't try to convince the cop that the cop is dumb and wrong. Instead of arguing with a cop on the side of the road, you wait until you get to court. Instead of arguing with the trial judge, you appeal. You pull a Karen and you go to the supervisor. Because you're not going to convince the judge that the judge is dumb and retarded. You have to convince the person who can force the judge to change the judge's ruling. That's who you have to convince. So this is Chili's motion to correct the record, nunc pro tunc. This is not technically a motion to correct the record. This is a motion for reconsideration, probably under Rule 54B, but the First Circuit might consider it 59E. I don't know exactly. Plaintiff Jose Decastro, plaintiff, or I, hereby moves this honorable court to correct its record under Federal Rule of Civil Procedure 60A, and correct its record of my motion to correct the recording of my notice of voluntary dismissal, which is true and in the interest of justice. In support of this motion, I hereby incorporate the attached memorandum in support. Well, what does Rule 60A say? This is the corrections based on clerical mistakes, oversights, and commissions. These are clerical mistakes, clerical oversights, and clerical omissions. This is where you get a judgment for like $260,000, and the judge puts the decimal point in the wrong spot and gives you $2.6 million instead of $260,000. Well, then the other side is going to say, hey, judge, do I need to file a motion, or can you correct this on your own? And the judge is going to be like, oh yeah, I totally didn't mean to award $2.6 million. I totally meant to award $260,000. It was a clerical error. I didn't make a mistake of fact. I didn't make a mistake of law. I made a mistake of where I put the decimal point. Because that happens. So the court may correct a clerical mistake or a mistake arising from an oversight or omission where one is found in a judgment, order, or other part of the record. The court may do so on motion or on its own, with or without notice. But after appeal, blah, blah, blah. This is literally to correct like a blatant error. Like I had ordered this particular thing. I told everybody that I was ordering it, but I forgot to write it in the judgment. Hey, judge, you forgot to write that thing you were supposed to write. Oh, yeah, I'm going to do a Rule 60A on my own, sua sponte, and I'm going to make sure I include that in the judgment. I'm going to amend the judgment on my own to include that thing I told you I would put in there. That's what this is for. This isn't where you have a litigant saying, Judge, you're dumb and you're wrong and you made a mistake, so I want you to correct it under Rule 60A. But let's see what Chili does. This is his memorandum. A memorandum is supposed to cite authorities and facts and marry the two together to make an argument as to why the moving party is correct. It's a memorandum of points and authorities, of facts and law. The court has said in ECF number 74, plaintiff has moved for the fifth time, see ECF numbers 55, 58, 59, 66, and 73, for the court to retroactively find that his notice of voluntary dismissal, the notice, was filed before defendants answered his complaint. This court needs to correct the record. Now, this might seem like a small thing. I don't really care about punctuation, but this is a big thing. It's a big thing. You need to show respect to the court. You have to give respect to get respect. And this is disrespectful. The court is the judge is the court. You capitalize court. And as an opener, okay, but to say this court needs to correct the record, I don't like the tone. Prove it before you say it. I guess this could be a conclusion rule analysis conclusion, CRAC format, but I doubt it is. ECF 55 is entered as a letter/request, non-motion. This is ECF 55. I'm writing this. It seems necessary to notify you to have this court escalate the investigation. He's asking for something. I don't know if anybody remembers, but see this letter request? This letter request, the court treated as a motion. The court construes the letter from a defendant as a motion, and the judge granted it. Well, guess what, Chili? The court construed the document that you entitled as a letter, let's see, number 55. You titled it letter request on motion, but the judge construed it as a motion. You were asking for something. You weren't sending a letter saying, hey, did you check out that latest movie? How about that sports ball game? Great weather we're having. You were asking for something. and the court construed it as such. And the court can do that. You saw the court do that for the letters that Josh Abrams and Kate Peters sent. And that was not an error when I specified that. And the ECF number 55 is entered as a letter request on motion. And that was not an error when I specified that, but maybe it needs to be corrected or clarified for this court. The document was a letter to the court letting it know what had occurred and where the best evidence was. I was hoping that the court would, on its own, as is able to under Federal Rule of Civil Procedure 60A, correct the record if it had information of a correction that was needed. The judge hadn't issued anything. The judge hadn't issued an order when you filed that letter. The judge hadn't issued any judgment. You hadn't filed something. The judge is not correcting a clerical mistake. You're asking the judge to correct your failure to file in a timely manner. That's a different thing. The order at ECF number 57 does not specify that ECF number 55 was a motion. You don't get an order if there is no pending motion. You don't get an order if there's no pending motion. But let's look at ECF number 57. An electronic order entered. The court held a status conference. It was attended by all parties to the action. During the hearing, plaintiff requested and was granted leave to file as a pro se litigant. He subsequently made use of the court's electronic filing system, and on October 31st, 2022, a motion for clarification and a motion to transfer. On November 7th, 2022, defendants Abrams and Peter each answered plaintiff's complaint and filed counterclaims. The following day, November 8, 2022, plaintiff sent an email to the clerk of the court in which he claimed that he had attempted to file a notice of voluntary dismissal, the notice, on November 6, 2022 at 12:17 p.m., i.e. before defendants answered, and attached to his email a screenshot of his browsing history on Google Chrome, which he described as metadata, as well as a PDF of the notice, which was dated November 5th, 2022. Thereafter, on November 9th, 2022, plaintiff electronically filed on the docket a letter that reiterated his claim that he filed his notice on November 6, 2022, and asked the court to investigate the purported, quote, missing file, end quote, and to, quote, correct the error in its record. Asking the court to do something is a motion. You are attempting to move the court to do something. Additionally, the order made a lot of assumptions prejudicial to me. Those are called findings of fact. The court found facts. The court has that role in motions and in bench trials to find facts. The court gets to determine the credibility of the things that you say. The court gets to place whatever weight on the things you say that it believes necessary. And it gets to come to a conclusion of fact. So you thinking that the order made a lot of assumptions, those are the findings of fact the court made. Those assumptions are findings of fact. ECF number 58 was filed in error. I emailed the clerk about this, and she let me know that she corrected the record to make that clear. Perhaps this needs to be made clear that it is not a motion on record in this action. It says filed in error, refiled with correction. But you filed it. And the correction you made, this is actually an amended motion. But you titled it weird. So, okay. ECF number 59, although it says second, I don't know how that happened. You titled it. You literally titled it. It was my first motion. So no, because you filed this one, then you filed this one, then the clerk did that, but you had already filed this. That's how that happened. But it doesn't matter. It doesn't matter. Like, arguing over how many of these motions that you filed is stupid. They've all been denied. It was the correction from the mistake that happened at ECF number 58, i.e. you included extra stuff in your initial filing that you didn't want the court to see, and you tried to undo it and take it back because you're dumb and you don't inspect what you're filing before you file it. Perhaps this does need to be corrected from saying second. No, it's not. Like, dude, you're focusing on the little nitpicky things. Focus on the bigger picture. The bigger picture is the court's already told you multiple times no, and you still keep filing motions. It's not how you titled them. It's the end result. The court told you no, and you're persisting in refiling. This court found ECF number 59 moot due to my filing of an amended complaint without any relevant authority cited. The court doesn't have to cite relevant authority. You filed a amended complaint. You filed a first amended complaint. You filed this. So once you filed this, once you filed it, all of the previous filings, all your previous complaints are null. They're gone. Let me see if I can make this a little more clear. And amended and supplemental pleadings. I guess it doesn't say in here. But once you amend a complaint, then the previous complaint is no longer a valid complaint. Once you've amended your complaint, your previous complaint is no longer operative. So any motions based on it are done. And you also, once you filed that amended complaint, you said to the court, I want you to, you're saying to the court, I want you to hear my trial. I want you to try my action. I want this to be here because you filed another complaint in that court. You said, here, judge this, Your Honor. After you said, I don't want you to judge anything. And they said, well, you know what? Here, judge this. But really, I don't want you to judge anything. That's weird and wrong and dumb. I'm still unable to find any authority that says that an amended complaint removes from jurisdiction any nunc-pro-tunc motions for correction from the court's jurisdiction. Well, then keep looking, sunshine. Keep looking. Use that LexisNexis. And while you're at it, it's funny. There's an art and a science to researching. Because you've got to know what to look for in order to be able to find it. And that sounds counterintuitive and kind of stupid and wrong, but you have to know what you're looking for to be able to find it. It's like when you're trying to go down some sort of an esoteric path that you haven't gone down before, and you know generally what you want. A lot of the time I spend researching in those situations, I'm actually looking for the words to put into the search engine to get me what I want, not actually getting the relevant results. I'm trying to find the words to use to get the relevant results. I know that sounds complicated and stupid, but you really do. Just have faith. You have to know what you're looking for in order to be able to find it. And you shouldn't be looking for something on nunc-pro-tunc motions, because that's not a very common thing for attorneys to say. He should look for what happens when you file an amended complaint. ECF number 66 was a motion for reconsideration of the motion to correct. I do understand there is no official motion for reconsideration in federal court, and that this would be considered an amended motion. No. It's a motion under either 54B, 59E, or 60B, depending on how that particular circuit kind of interprets it. 54B deals with interlocutory orders. It's this part. Otherwise, any order or other decision, however designated, that adjudicates fewer than all of the claims or rights and liabilities of fewer than all the parties does not end the action as to any of the claims or parties, and may be revised at any time before the entry of judgment adjudicating all the claims and all the parties' rights and liabilities. So this is one way that the court can revisit it, that you could do a motion for reconsideration. The other one is altering or amending a judgment. They always cite to motion to alter or amend a judgment. A motion to alter or amend a judgment must be filed no later than 28 days after entry of the judgment. This is normally reserved for non-interlocutory, things that actually end the litigation. So like a motion to dismiss or something like that. Or a motion denying a motion denying an amendment to a complaint, something like that. And then the final way is 60B. Whoops. 60B. This is grounds for relief from a final judgment order or proceeding. This is a final judgment order or proceeding. Despite the titles, a lot of the courts will use like 59E. What they're looking for there are one of two things: either facts, new facts that you could not have known prior to the order being granted or denied. New facts you could not have known. It's not I just effed up and failed to plead them, but it's a fact that, having done your due diligence, having taken all reasonable steps to find and put in all the facts that you need to put in, having done that, if there are new facts that came forward or facts you couldn't have known, then you can ask for it under 59E. And the other thing is where the court has completely effed up the law. Like they cited entirely the wrong standard. They cited a law that's been, or a rule of court, like a way of determining things that's been overturned. It's no longer stare decisis, and there's a new way that they have to view it. But it has to be something that's a blatant error of law. It has to be, they call it a material mistake of law. And it means it has to be like in your face, like no arguing it, like this is just blatantly freaking wrong. So it has to be one of those two things normally. So that's how you get motions for reconsideration, and it would not be considered an amended motion. It's a motion under 54B, 59E, or 60B. That is not an additional motion. He's trying to argue technicalities with the judge. This is going to work great. but it is also proper for my exercising my due diligence at the error made by this court. So now the court made the error. Well, isn't that special? And this court found ECF number 66 moot due to my filing an amended complaint without any relevant authority cited. Didn't we just do that? 59 and 66 were the amended complaint. So 59, and then, oh, they don't have 66 in here. Wait, here's 66. Seeks reconsideration, relevant here. He filed his second motion to correct his supposed error. Amended complaint. Here we go. Oh, look at this. This looks like authority. Oh, would you look at that? Would you look at that? It's Intergen NV versus Greena, citing Kelly v. Crossford Catalysts. Wow. That looks like authority. Without any relevant authority cited. So according to Chile, the authority cited by the court is not relevant. Huh. An amended complaint supersedes the original complaint. In other words, by filing the amended complaint, plaintiff replaced the original complaint and mooted any motions related to it, including his motion to retroactively change the filing date of his notice of dismissal. It seemed like this court was saying that I needed to bring the motion back into the court's jurisdiction by filing it again. What does that mean? What does that mean? It seemed like this court, again lowercase c, was saying that I needed to bring the motion back into the court's jurisdiction by filing it again. I don't see the court asking for that at all. ECF number 73 was logically my first and only motion to correct, since the others were found moot and were not within this court's jurisdiction according to its erroneous rulings. The court never said it was within its jurisdiction. The court said it was moot. You're still trying to do the moot thing. You're still trying to do the moot thing. Additionally, this motion did include additional arguments and cited authority for its arguments. Yes, and they were all shit. This court has said that plaintiff has not pointed to any evidence that indicates he actually filed his notice before the defendants answered. This is incorrect. I said in my very first letter to the court that the court has the best evidence and this case shows this court how to use the evidence. Well, no, see, like, in his first letter to the court, he said the court had the best evidence. But did he say that I filed it? On October 6, 2022, I e-filed a notice of voluntary dismissal for this case after you indicated it as an alternate to my motion to transfer. So he is saying he e-filed it. I filed the notice for voluntary dismissal. He did say he filed it. So he said it. He's right. I also requested an evidentiary hearing. Good job. You know, one of the things that I see a lot. I see a lot, especially on like Discord and places like that. Show me where I said this, or I said this. Like when either they refuse to scroll up and read what's already been said, or they tell you what they've already said, as if you haven't read it. I assume that the court read these things and came to its conclusions. And court said plaintiff has not pointed to any evidence that indicated he actually filed his notice before the defendants answered. Let's see where she said that. So this is in 74. As the court explained in its prior orders, plaintiff has not pointed to any evidence that indicates he actually filed his notice before defendants answered. First, although plaintiff claims to have filed the notice on November 6th, so right there she's acknowledging that he said. There's no evidence that he did so. So she's discounting what Chili's saying. She's saying, I don't believe what he said. She says, although he claims to have, he's not pointing to anything. Now, she could believe him, or she could not. As the finder of fact for this particular circumstance, she gets to make the decision on what she believes and what she doesn't, and on how much weight she applies to anything he says. So he's arguing things that she acknowledged. She said that he claims to have filed the notice. Great, but he doesn't show anything to back that up. Oh, and here we go. The court has said, although plaintiff claims to have filed the notice on November 6th, there's no evidence he did so. In fact, plaintiff himself acknowledged in an email exchange with the clerk of the court. And he cut it off. I again refer you to the previous paragraph. But what did he acknowledge in the exchange with the clerk of the court? Which he appended to ECF number 58, that even assuming he did attempt to file the notice on November 6th, it didn't work. This is 58. This is 58. Well then, it didn't work. Perhaps I made an error. As you can see from the Google metadata, I thought I did it. I thought I did. Not I did it, I thought I did it. And he says, I again refer you to the previous paragraph. Okay? There is evidence, and my being polite and reasonable and admitting other possibilities in an email to the clerk was not an admission of a mistake on my part. Yeah, it is. It's an admission that it could have been a mistake. And anything you say can and will be used against you. Keep your pie hole shut. And saying there is evidence, you don't know. Because if you had the evidence, you'd be able to pull it out. But you're saying, aha, the court needs to provide some sort of technical assistance. We need to be able to have an evidentiary hearing with the court's technical staff to find the evidence. That's different than saying there is evidence. You can't actually point to evidence. You're pointing to the possibility of evidence. And you're not smart enough to know what an offer of proof is. Even if there was an error on my part, see, again, you're admitting that there might be an error on your part. Again, you refer you to Worters versus Mass. Again, this is a a district court case. It is not even published. It's not even published. That says ECF system requirements aren't considered filings. Is this one of the ones I could find? It's not one of the ones I could find. It's not one of the ones I could find, so I can't tell what it is. But it is definitely not published, which is why you have a Lexis citation, i.e. LexisNexis. It's not a published decision, and it wouldn't even be stare decisis. It might be persuasive, but it might not. I can't tell you because I can't read it. So who knows if it actually says that the ECF system requirements aren't considered filing? Who knows if it says that? It would be reasonable for this court to also admit the possibilities of errors with its ECF and the case law that clarifies the lack of importance of the ECF requirements and allow this court to have a hearing of the evidence. But it doesn't have to have an evidentiary hearing because the court has already made determinations of fact sufficient to allow it to rule on the matter. Denying the evidentiary hearing that could easily prove my attempted filing per pipe fitters is a travesty of justice. Well, if you say so, I mean, who could argue with that? The court has said, moreover, the search history, which plaintiff refers to as metadata, that plaintiff has repeatedly submitted to suggest he attempted to file his notice on November 26, 2022, shows only that he visited the electronic filing website, not that he filed any papers with this court. That is also incorrect. The title of the page shown in the history is specific to when you're in the civil document submittal process. Additionally, I just now realized that the history that I printed does not show URLs, but it also, as I keep saying, is not the best evidence. The court has the best evidence. The first relevant URL is simply that, followed by that. And then after that, it's just random numbers for each page of the forms. So it doesn't show what you think it shows. This seems best when combined with the court's evidence. This is again, you're assuming that the court has this evidence. And it may not. But you don't get to make the court put its tech guy up on the stand. Upon finding that I submitted this without your URL showing, I will amend my first motion after previous moot motions to include this new evidence. Yeah, the court's not going to give you the evidentiary hearing. This court said, quote, regarding the emails to opposing counsel, the plaintiff contends support finding that he dismissed his case before the defendants answered. I think you read the exhibit annotations incorrectly. The emails to opposing counsel were to address your argument of there is no evidence to suggest that plaintiff drafted the notice or in 57. It's a strange place to end it. Or attempted to file it. Oh, see, or attempted to file it. Or attempted to file it. So he's just saying that he had drafted it. This shows that I drafted it, but that's not the relevant thing. It's not relevant that you drafted it. The question is, did you file it? However, see, in Houston versus Lack, where notice was sufficient, this is the, I think this was the prison case, right? This is where a prisoner gave his motion to the guards. Yeah, he gave the motions to the guards, and it took them too long to get it filed. Where notice was sufficient absent filing for motions that require filing to become effective. Yeah, and it was because he was a prisoner. He could not file it himself. He had to give it to his guards to file, and they're the ones who effed him. So it wasn't his fault, but you had access to a computer, you had access to the internet, you showed that you actually got to the page, but you didn't hit the button. Additionally, it's clear that the defendants couldn't be prejudiced by correcting this error since they had notice. They would be prejudiced. They literally would be prejudiced because they now have counterclaims filed, and they would lose those. So yeah, they would be prejudiced. They also failed to complain to me that they didn't see the notice on the docket until after they filed their answers. They don't have to. They don't have to complain to you that you were too stupid to hit the button. They also seem to have a change of heart as to the dismissal of this action, as they had moved for its dismissal previously. Had they moved for its dismissal previously? Had they moved for dismissal previously? That was an emergency motion to dismiss. Yeah, well, maybe you should have not opposed that, huh? You seem to have had a change of heart too, didn't ya? Because you opposed that emergency motion to dismiss, didn't ya? And now what? Isn't this court in the habit of disallowing changes of heart? Wait, what? That's the dumbest shit I ever heard. The courts want people to have changes of heart all the time. The court wants people to settle, which requires changes of heart. You're going from I'm going to sue you to I'm going to settle with you. That's an enormous change of heart, and the court wants that. This court said Local Rule 5.4a states that unless exempt or otherwise ordered by the court, all pleadings and other papers submitted to the court must be filed, signed, and verified by electronic means as provided herein. As I mentioned in Warders, local rules were hardly created to prevent justice and to prevent Rule 41a actions that were filed except for an error with the ECF. Well, you haven't proved to the satisfaction of the court that there was an error with the ECF. So that argument is shit. Additionally, Phoenix Globe Ventures, haven't I gone through all these? They were all garbage. The ones that I could read were all garbage. But let's check it out. So this is Second Circuit, so it is persuasive at best. The motion for remand was untimely. So it recognizes the inherent authority of a district court to overlook violations of or depart from its own rules. So the court may overlook violations of or depart from its local rules to permit a district court to similarly overlook failures to comply with requirements. So the court may. This is not mandatory that the court must overlook these failures to comply with requirements. It may. Additionally, so this thing that says the court may overlook violations of local rules makes it clear that my declaration that I filed the document should be sufficient. No, it doesn't. You are making findings against my credibility with no justification. The finder of fact doesn't have to justify who they believe or why. So, no. It is defendant Peter that is known for forging court documents, not me. Okay. What did she forge? What court document did she forge? And I know you're going to say, oh, she forged that complaint and that against Turtle Boy. Yeah, but she didn't file that with the court, so I don't consider that to be the same thing. So sorry. Sue me. Defendants did not challenge my statements, only indicated that they prefer the case not be dismissed. I don't think they had to challenge your statements. This court has offered no evidence that would defeat my declaration or evidence. The court doesn't have to offer evidence. The court, in fact, does not offer evidence. That is not the role of the court. The court is to judge the evidence, judge the facts, at least in this particular instance. Obviously, it doesn't do it where there's jury in play, but in a motion hearing or where the court is sitting as where it's a bench trial, then yeah, the court determines what the facts are. It doesn't offer evidence. Dummy. You would think a 20-year constitutional scholar would know that the court does not offer evidence. Additionally, see in Houston, where notice was sufficient absent filing for motions that require filing to become effective. Again, you're citing to a case where it was a prisoner situation. This court said that the clerk of the court said, plaintiff had not filed anything on the court's electronic filing in the month of November. A colleague has checked for me and said that you do not have any Pacer transactions for the month of November. First off, I think it's obvious now that the document did not appear on the docket. Wow, first off, I could just see him with his little finger up in the air. First off. Oh, he's so gay. Not in a bad way. I'd smash. First off, I think it's obvious now that the document did not appear on the docket. Yeah, I mean, duh. That's obvious. It didn't appear on the docket because you didn't file it, dummy. This is an obvious statement. It does not show that there was not an error that led to that. Yeah, you failed to hit the button. The statement was also hearsay. From an anonymous source. Yes, it was hearsay. Just like your entire motion here is hearsay. And it's not anonymous. I mean, we know who said it. It was Caitlin McManus. So it is not hearsay. Excuse me, it is hearsay. But the court can on motions it does things on affidavit, etc. And your dumbass is the one who put it in an exhibit. You're the dumbass who put it in an exhibit. You gave that to the court, you dum-dum. We do not know the extent of expertise of this person or what they did, even other than look at the document. We don't know what her colleague did. That's correct. We don't know what her colleague did. That's correct. But you could also look at the actual ECF filing record and see that prior to November somethingeth. So here's November. This is an order. November 7th is an answer from Abrams, answer from Peter, and then the 9th. So as of the date she sent that email, you could look at this and you could the court can take judicial notice that nothing was filed. Doesn't even need that person. We don't need to know the extent of the expertise of that person or what they did other than look at the document. The statement was not, plaintiff has not attempted. See, attempted, but it doesn't, you don't get bonus points for attempting to file. You have to file it. Plaintiff had not attempted to file anything on the court's electronic filing in the month of November, nor was it, there were no errors in the ECF system. But yeah, you can't point to errors, and you said that you may have made a mistake. Conclusion, for the aforementioned reasons, I pray the court will correct this record of my motion to correct to reflect that it was only made once before being erroneously ruled moot, and then once to bring it back into the court's jurisdiction. That's weird. I respectfully request that this court take the steps necessary to protect its evidence in the form of digital records of the ECF system that shows all my activity and not just successful activity free of error related to this incident on November 6, 2022 and November 7, 2022. Good luck, Chuck. I would love to see the subpoena that you try to issue to get that whatever the hell you think you're going to get. I would love to see it. Declarations, yada yada. Again, a request for a hearing and certification of Local Rules 7.1A2. Yeah. All right. Well, there you have it. That was pretty lame and dumb and wrong. Sorry for the long video. Anyway, the court has not yet denied this. I anticipate the court will be denying it shortly. Presumably, if Judge Burroughs is good to her word, she will deny it without any comment. And the plaintiff is ordered not to file any motions seeking the same relief, relying on the same arguments that have been denied 5 times over. Technically, this is a new argument, I'm going to say. Well, I mean, generously speaking, it's a new argument. I don't really think it's a new argument. He's arguing the facts, not arguing new points of law. Should plaintiff file another motion on this topic, despite being ordered not to, the motion will be denied without further explanation. I think we're going to get it denied without further explanation. I think there is a 33 1/3% chance that the court will tack on a further motions will subject you to sanctions, or potential sanctions, will potentially subject you to sanctions, something along those lines. But we'll see. Anyway, thanks for watching. Have a great day.